Τώρα έχουμε την μεγάλη χαρά να έχουμε φως και εικόνα από τον κύριο Πελεκάνο, δεν τον έχουμε μαζί μας, ο οποίος θα μας δώσει και μία άλλη φιλοσοφική διάσταση και αυτό έτσι ελπίζω με αυτό θα κλείσουμε και αυτή την ενότητα.
Dear colleagues, ladies and gentlemen, a brief word of thanks to Professor Kalavros and the Diatesia team, and Professors Bamboukis and Brekulikis and my co-panelists, and a special thanks to Mr. Panosakoulas for accommodating this video presentation, which unfortunately was necessary because I've been called away to appear in court outside Athens. Professor Brekulikis' essential proposition is that arbitrators are not given a wide discretion on the basis of morals or values to decide on what ought to be public policy, because in effect they substitute the legislator and they are judges, not lawmakers. This proposition has certain philosophical and legal ramifications, which I shall endeavor to discuss, although I fear not conclusively resolve. The philosophical background can perhaps be discussed in a combining David Hume, Immanuel Kant, and Wittgenstein. David Hume, in his treatise on human nature in 1793, pronounced the well-known formula that one cannot derive an ought from an is. The apparent gap between ought statements and is statements renders ought statements of dubious validity. Values are ought statements. Therefore, whenever an arbitrator bases an argument or a judgment on an ought, she confuses it with an it. Kant credited Hume for getting him out of his dogmatic slumber. He built on the is and ought distinction and presented the fact versus value distinction, and that reason is the only ground for morality. This influenced a whole era of thinking, especially Austrian thinking, prior, during, and after World War I, in architecture, music, literature, and philosophy, culminating in Wittgenstein's Tractatus. Aware of the fact that I'm probably butchering Wittgenstein's thought by taking his statements out of context, he said, "The world is the totality of facts. The world, everything in the world, everything is as it is, and everything happens as it does happen. In it, no value exists. And famously, whereof man cannot speak, thereof man must be silent." The commonly understood interpretation of Wittgenstein's thinking is that man cannot speak of the metaphysical, values are metaphysical, therefore ineffable. Values, therefore, can only be shown, perhaps by poetic language, but not spoken of in any real sense. The legal significance of all this is the following. In the theory of law, the discussion of transnational legal orders in the sphere of arbitration is associated with the School of Dijon, to which Professor Brekulikis himself alluded when he references Philippe Fouchard, a member of that university's faculty. In summary, the School of Dijon asserted the existence of autonomous, non-national dispute resolution systems revolving around arbitration mechanisms, which allegedly formed their own transnational legal order. The primary criticism against the School of Dijon came from Kelsen and the School of Legal Positivism. After World War I and the breakup of the Austrian-Hungarian Empire, Austrians, like Kelsen, took it upon themselves to create a new state. Theirs was a world of practical life, practical issues to be resolved, to create a constitution, to establish a democratic state as the source of legality in place of emperor and empire. It is no surprise, therefore, that the is-ought distinction, the fact-value distinction, found its way into legal thought. There is no law outside the state law. There is no other justice than the justice to be found in the positive law of states. There is an analogy with international law that is perhaps worth looking into. We all know that there are four sources of international law: the law of treaties, international customary law, and to a lesser degree, the general principles of civilized countries and the opinions of legal authors. Transnational law in itself is somewhere in between national and international law. Where exactly, the definition is unclear. Clearly, the minimum is 2 or more countries' legal systems. Transnational public policy, therefore, is the public policy of 2 or more states. It is interesting to note what Professor Georg Schwarzenberger, again another Austrian, a university professor in London, at the University of London, professor of international law, has to say. Terms such as international jus cogens, international public policy, are analogies from national law. The scope of public policy, ordre public, and other synonyms on the national level differs from country to country, and the legal effects of rules in this category differ similarly. The rules of national jus cogens, continues Professor Schwarzenberger, have 2 features in common. They are public law in the strict sense, parties cannot deviate from them by agreement, and secondly, they are prohibitory rules, that is, they prevent individual parties from taking action which they may desire to take, but are contrary and incompatible with such rules. Professor Schwarzenberger continues, transnational law is intended to describe legal relationships which neither international or national law is supposed to cover adequately. In existing law, the purely negative character of this term limits its users to systematic purposes. Even so, its existence encourages natural abuses, such as the deduction from the nature of things of legal rules, whose nourishing ground is usually one of the few national laws known to any particular transnational lawyer. A few national laws, 2 or more national public policies, is a poor basis from which to infer that an ought should be applied generally. The claim that values and morals could possibly be the basis for issuing legally relevant decisions requires evidence that these values and morals have transcended to the status of international law. Priority is reserved to international law of treaties and international customary law. The tests are vigorous, and any such claim would need to demonstrate that a rule has graduated to the status of at least international customary law. There is perhaps one exception. What happens where there is no agreed formal law as applicable law governing the resolution of a dispute? If there is no agreed formal law, all the parties have agreed that the arbitrators will decide it ex equo and bono, the contractual basis of the arbitration may allow values to infiltrate and indeed make new rules inter partes. The ground for this argument can be found in paragraph 2 of Article 38 of the Statute of the International Court of Justice, according to which if the parties to a case before the ICJ so desire, they may authorize the court to decide a case between them ex equo and bono. In this eventuality, the court may dispense equity justice so as to override actual rules of international law. In a sense, it is a case of international law disallowing its own application because the parties have so agreed. But again, where an award issued on the basis of ex equo and bono is sought to be enforced in a national legal system or recognized, public order compliance will be necessary. So to conclude, only if the dispute is resolved within a voluntary, contractually based system to which the parties have knowingly and voluntarily acceded and submitted, such as a club with its own system of values and sanctions, or where the arbitrators decide ex equo and bono, these club values and these arbitrators' values can be implemented within the system on the basis of the parties' agreement. And to make a point, there is no body of values in the sense of a transnational law floating somewhere in between national and international law. And no ex equo and bono arbitrator's decision is in itself equivalent to national or international law. And at this point, I fear I've reached my limit, and I follow Wittgenstein's advice to be silent. Thank you.